Today's lunchtime seminar is Unfinished Business, Old Challenges and New Law Reform on Child Marriage, and our presenter is Rangita de Silva de Alwis. A rash of legislation combating child marriage and pledges to political leaders, including those in Bangladesh and Malawi, to fight child marriage in those countries reveals some loopholes in the law that roll back the promise of law reform. And during this presentation, Rangita is going to consider recent legal revisions in Bangladesh and Zimbabwe, along with comparative perspectives of Malawi and other countries, including here, to determine the promises and potential pitfalls of such reforms. Two important reformist initiatives have captured the attention of women and their governments in these countries where child marriage is a pervasive issue. And today, Rangita is going to examine the complicated definition of the best interests of the child in Bangladesh and Zimbabwe against the backdrop of changing legal landscape for child marriage. And throughout her career, Rangita, a human rights legal advisor, has worked with networks of global institutions, civil society, and government organizations to develop human rights initiatives. She's a senior scholar here at WCW and was the director of our international human rights policy programs until 2012. And then she had become the inaugural director of the Global Women's Leadership Initiative and the Women in Public Service Project that was launched by Secretary of State Hillary Clinton. And it was launched here at Wellesley College, and then it went to all the sister schools that were involved before moving over to the Woodrow Wilson Center, and she went as well. So Rangita is currently the Associate Dean of International Affairs at the University of Penn Law School, where she teaches international women's human rights law. And she has several appointments through the UN, which she might share with us today. If you would, please hold questions till the end, and we will have time for some lively discussion. And join me in welcoming Rangita de Silva de Alwis.
Thank you. Thank you, Donna. It's wonderful to be back in this magical place, which was not just home to me, but nurtured me. And it's so lovely to be back with people whom I consider family. Nan has been and continues to be such an integral part of who I am. And thank you, Nan, for being here. And Lily, thank you for leading this magical place to greater heights. So I'm going to start very quickly with a story. When the Qazi, the Muslim marriage registrar in Dhaka, Bangladesh, saw my daughter's age on her birth certificate and saw that she was 13, he took it to the local government chairman and got it changed to 18 and then performed the marriage. My family paid 100 taka, $1.30 to the chairman to change the birth certificate. So this is testimony from the Bangladesh National Women Lawyers Association, the leading women lawyers association in Bangladesh, with whom the Wellesley Centers for Women had a close relationship at the time that I worked with BNWLA. So I'm back. I'm back again at Wellesley Centers for Women to mark the 70th anniversary of the Universal Declaration of Human Rights, which calls for the dismantling of all forms of discrimination, including gender discrimination. And as recently UN Secretary General Guterres, referencing the extraordinary moment for women's mobilization around the world, has exclaimed, everywhere women are saying time is now. Women are calling out against discriminatory attitudes, customs, laws, and practices. And this new mobilization is finding new words like Me Too and Time's Up to change old problems. Problems that we have been dealing with all through our lives. And Hillary Clinton, I have to come back to Hillary Clinton because she has said child marriage is a personal commitment. Ending child marriage is a personal commitment, she has said. And she said that to Nelson Mandela when she met him in 2012 at a moment when he had started Girls Not Brides movement to end child marriage. And as you all know, she wrote in her latest book, the movement for gender equality is the story of my life. We share it, we wrote it, but there is still more to it. And I have not just been a participant in this revolution, I have helped to lead it. And we all, as part of Wellesley, are part of that revolution and part of that story that still is being written. So ending child marriage too is a part of that revolution, and eradicating child marriage addresses a number of the Sustainable Development Goals on poverty, nutrition, health, education, economic growth, and the reduction of inequality. Ending child marriage will lead to higher educational attainments, higher earning potential, better maternal mortality, and there is no greater investment than in ending child marriage. But although it has enormous development consequences and ramifications, child marriage is primarily a violation of human rights and human security. And we can never let that bedrock value of human security and human rights be undermined in this race for development. So what are the pressing rationales in ending child marriage? Anthony Lake, the head of UNICEF, has said that by 2025, if there is no greater intervention, there will be 1 billion girls who will be brides. 1 billion girls. I repeat that. Forced marriage is a form of sexual violence, and sexual violence is the great moral cause of our times. And we see that child marriage increases in conflict. Whereas the number of early and forced marriages increase significantly in situations of armed conflict and humanitarian disaster, it also increases during a time of migrant crisis, because many parents seeking to protect their daughters from sexual aggression choose to have them marry before the age of 18. So that is why this is the cause of our time. So very quickly, I want to do a tour de force of the legal framework that is available, the international legal framework that enshrines anti-discrimination provisions that are important tools to end child marriage. As we all know, the Convention on the Elimination of Discrimination Against Women enlarges our understanding of the concept of human rights and international law. But what it does at its heart that no other convention, no other international norm does, is that it seeks to influence culture and traditions that disempower women. And this was a real breakthrough, a revolution in international law, because as we all know, international law, before the advent of S.J.D, was seen as a set of norms or a corpus of laws that regulated state action and not private lives, private institutions, and private family arrangements. But S.J.D's revolutionary cry in Article 5, which calls for a change in the traditional role of men as well as the role of women in society and in the family in order to achieve equality of men and women, was a real breakthrough in international lawmaking. And so what Article 5 does is that it calls for the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes on stereotyped roles of men and women. Article 10, too, is an important tool in the arsenal of anti-child marriage, because Article 10C mandates the revision of textbooks, school programs, and teaching methods with a view to eliminating stereotype concepts in the field of education. So we have the Convention on the Elimination of All Forms of Discrimination Against Women, S.J.D, and then we have the Convention on the Rights of the Child, which calls for the best interest of the child as the primacy of international laws in protecting the rights of children. And the S.J.D Committee in General Recommendation 21 also has stated very clearly that the minimum age for marriage should be 18 years for both men and women, and marriage should not be permitted before they have attained full maturity and capacity to act. And then finally, in 1995, at the Fourth World Conference in Women in Beijing, and I know that the Wellesley Centers for Women played a role in shaping that major convening of global women, also stated very clearly that the world and governments must revoke any remaining laws that discriminate on the basis of sex, including early child marriage. So we have a corpus of laws that are important tools in our war against child marriage. But at the same time, we have what is now known as the most ambitious development agenda of our time, the Sustainable Development Goals, where nations have committed to goal 5.3, which calls for ending all harmful practices, including child marriage. And once again, the Sustainable Development Goals have really created new paradigms, a new vernacular for us to talk about ending child marriage, because now ending child marriage is not only a human right, but it is a priority in the development agenda. So it is part of the primacy of development goals that are enshrined in the Sustainable Development Goals. So that's the international corpus. So what is the national law? What are the national law frameworks that are important in combating child marriage? As you said, Donna, in conceptualizing this discussion, a rash of legislation combating child marriage and pledges by political leaders, including Sheikh Hasina, the Prime Minister of Bangladesh, and Joyce Banda, the former president of Malawi, whom I know was on campus a few months ago, have a pledge to fight child marriage in their countries. However, the laws, even when they are revised, reveal loopholes that roll back the promise of law reform. So what I'm going to do is use two case studies, one from Bangladesh and one from Zimbabwe, from South Asia and from Africa, to look at the ways in which even when there is good faith law revision, there are cultural practices and traditions and loopholes in the law itself that roll back and undermine the promise of these laws. So in both countries, child marriage is pervasive. Bangladesh has one of the highest rates of child marriage. 52% of girls are married by the age of 18, and 18% are married by the age of 15, and 71% of girls in rural areas are married before the age of 18. In Zimbabwe, according to UNICEF data, 32% of girls are married by the age of 18. So this is pervasive. Child marriage is pervasive and is one of the greatest plagues in both these countries. So while I examine child marriage in Asia and Africa, it is also important to remember that between 2000 and 2010, nearly 4,000 children under 18 were married off in New York State. So child marriage is a universal issue and certainly not limited to South Asia or Africa. In 27 US states, there are no age limits to how young a child can marry with the sanction of a judge. So despite a new law introduced by Governor Cuomo in New York in 2017, even this law falls behind internationally sanctioned norms of age 18 as the minimum age of marriage. The new law, introduced first in 2016 and then reintroduced in 2017 in New York, prohibits all marriages before the age of 17 and permits 17-year-olds to marry with a judge's permission. So these are some of the loopholes in the laws. So, despite recent efforts to outlaw child marriage, the laws in the books reveal these legal loopholes. So let me look at what these loopholes are before we come to Bangladesh and Zimbabwe in some of the other countries to look at some of the hypocrisy behind these laws. So in Iran, the minimum age of marriage, according to Section 1041 of the Civil Code, a marriage can be arranged at 9 lunar years for girls and 15 lunar years for boys. Further, marriage below this age is also permissible by the permission of the guardian and on condition of taking into consideration the ward's interest is proper. So again, what you see is this kind of capricious ambiguous provisions in the law. What is the ward's interest to get married before the age of 9? How can that even be in the interest of the ward, the child? Then Nigerian law, the Child's Rights Act of 2003 prohibits child marriage. However, it has been noted that the law sets the age of marriage at the age of puberty, rather than the age of maturity at 18. So you see how there is this lip service made to law revision. So there is this almost effort made by governments to change the laws in an effort to pay lip service to international regulations, and because there is some other political agenda that is at play. But however, there is also this kind of what I would say beneath the surface attempt to prevent the law from being actualized. And this is a deliberate prevention by the government, by the lawmakers, to hijack the agenda to change the law. Similarly, Chad's Article 144 of the Civil Code sets the minimum age of marriage as 15 years, while according to the Criminal Code, customary law marriages of girls above 13 are legal. So you see, on the one hand, there's this juxtaposition of legal reform in the Civil Code, but then there are other laws that still allow for customary laws. And then these customary laws conflict and collide with legal system reform. And there is no way in which these laws can be reconciled. So there is no hierarchy, a sense of hierarchy of the formal laws against the customary laws. And there is a sense that there is no primacy given to either the constitutional provisions on equality or the legal reform that is being done in so-called good faith. So what we see is that despite law reform, loopholes legally permit child marriage, even in countries that ban child marriage, and the consent of the guardian or the court is allowed to override some of these conditions that are enshrined in the laws. So, bringing the national law in compliance with the Zimbabwean constitution. In January of 2016, the Constitutional Court of Zimbabwe ruled that the Marriage Act, which allowed girls as young as 16 to be married with their parents' consent, was unconstitutional because the Constitution of Zimbabwe of 2013 stipulated that no person may be compelled to enter marriage against their will, and calls on the states to ensure that no children are pledged into marriage as an important step. So this is, to me, an important forward-looking principle where the Constitution itself prevents and outlaws child marriage. So this is at the constitutional level. So there is a sense that this is being enshrined at the supreme law, in the supreme law of the country, in the supreme law of the land, which is the Constitution. In August 2015, Zimbabwe launched the African Union campaign to end child marriage, and many civil society campaigns, including the 18+ campaign, the Give Us Books, Not Husbands, and Not Ripe for Marriage campaign, helped to bolster this law reform and the case that went before the Supreme Court. So now, what was the case about? On 20th January 2016, the Supreme Court held this appeal on 2 cases brought by 2 victims of child marriage, where the prior sentence for the child marriage was at 12 months. And the Supreme Court held that this was far too lenient because in both cases, both girls had been impregnated. While one of the accused took the young girl for his wife, the other girl was given $2 and $1 after each intercourse. Both accused were charged with contravening Section 70 of the criminal law, having sexual intercourse with a young person. However, the Supreme Court held that the sentences handed down appear to trivialize the protective measures for young persons prescribed in our law and in the current international framework for safeguarding young persons. And the Supreme Court further went on to say that it is in the paramount best interest of the young person to hand down a sentence that fits the crime. So this is the way the Zimbabwean High Court defined the best interest of the child, that it is in the paramount best interest of the young person to hand down a sentence that best fits the crime. It went on to cite international law, it went on to cite the African Charter on the Rights and Welfare of the Child, but to me what is most striking is the way in which the best interest of the child notion was interpreted and defined in the way it was meant to be defined by the Convention on the Rights of the Child. So now let's go to the Bangladeshi case study and look at the way the Bangladeshi law defines and interprets the best interest of the child notion. So to tackle child marriage, Sheikh Hasina, the Prime Minister of Bangladesh, made commitments at the Girls' Summit in July 2014, and she promised to create a national plan of action by the end of the year. Her idea was to revise the Child Marriage Restraint Act and end the marriage of girls under 15 years of age and reduce by 1/3 marriages of girls between 15 to 18 by 2020 and eradicate child marriage in the country by 2030. So lofty goals. And this was a pledge that she made in 2014 before the Girls' Summit. So in order to fulfill her commitments to the Girls' Summit, she asked the Parliament to pass the Bill on Child Marriage Restraint Act, which was passed in 2017 February. And the President signed this bill in law. However, although this law made some good faith efforts to increase the punishment for child marriage, you see how there is this very subtle, insidious, and very determined effort to go one step forward and two steps back in law reform. So what the law states, this is not the custom, what the law itself that was revised states is that a marriage can take place under special circumstances with the permission of the court and with the consent of parents if it is in the best interest of the child in question. So this is really a co-optation of the best interest of the child principle. So you are taking the best interest of the child principle in order to meet a political goal of ensuring that the religious majority and that the religious community is appeased by this revision in the law. So it is going one step forward and then getting two steps back. So Prime Minister Sheikh Hasina and other government officials have argued in every public conference that this unusual exception, and they do acknowledge it is an unusual exception, is in the law to protect, that's the vernacular that they use, to protect unwed pregnant girls from being stigmatized. So the head of the parliamentary committee, a woman, and the spokesperson for the Ministry of Women and Children's Affairs has gone on record to say, our rural society is very cruel. They will point their fingers at the pregnant girl. She will be an outcast in school and elsewhere. People will say nasty things to the girl's parents. And therefore, this is a rationale for a provision in the law that calls for and allowing of a child's marriage in her best interest. So this co-optation, the using of the international legal principle in order to legitimize and make credible an illegitimate act is a way in which the law itself is used to undermine human rights. And the law itself is used to subvert human rights principles and subordinate women's rights. So what does the best interest of the child mean? Article 3, paragraph 1 of the CRC, the Convention on the Rights of the Child, gives the child the right to have his or her best interest taken into account as the primary consideration in all decisions concerning the child. The best interest principle is set out in Article 3.1 of the CRC, which says all actions concerning children, whether undertaken by public or private or social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interest of the child shall be the primary consideration. It's the paramount consideration. However, the UN Committee on the Rights of the Child was aware of the ways in which the best interest of the child could be misinterpreted, and has said that that the UN Committee on the Rights of the Child, which is charged with overseeing it, has said in General Comment 14 that the best interest standard is vulnerable to manipulations by governments. and that General Comment 14 obligates state parties with the ultimate purpose of pursuing the child's best interest to ensure the full and effective enjoyment of the rights recognized in the Convention, including the right to an education, the right to information, and his or her reproductive health. So what the committee has said is you cannot take this in isolation of all the other principles in the Convention. So therefore you cannot take the best interest of the child and alienate it and separate it from all of the other principles and guarantees and values and the very spirit of the Convention, which calls for the fulfillment of the child's right to health, education, and reproductive health. So the best interest of the child, however, in Bangladesh has been rendered meaningless because it is not seen in the context of the Convention, and the Bangladeshi parliament has failed to appreciate that child marriage cannot be in the best interest of the child because it undermines the very notion of the best interest of the child. So then finally, what are my recommendations? Closing the loopholes in the law, obviously, would be number one. But then, as my discussion has indicated, as Donna indicated in introducing this, that what we've seen is that laws alone are inadequate to address child marriage. So just recently, I was asked by the European Parliament to review its proposed resolution before the European Union, which calls for the EU strategy against early and forced marriage by the Committee on Foreign Affairs. So they just sent me this. I will be speaking at the EU Parliament in Brussels in a couple of weeks at a panel discussion that will be moderated by the parliamentarian who is lobbying for this resolution. And what is so interesting in this resolution is that it recommends that member states align their legislation on the treatment of immigrants and not to recognize early and forced marriage while extending humanitarian treatment to those who are married before the age of 18. So it's a way of balancing this, right? So, those children who have already been married need to be protected, but those other migrant families who are coming into the receiving countries need to be seen in compliance with international human rights norms. And it becomes better, it becomes more interesting. Keeping with the Human Rights Council's commitments, calls on the European Union in the context of its foreign policy and its development cooperation policy to offer a strategic pact to its partners to end child marriage. So this is exactly what Hillary Clinton was envisioning in 2012 when she met with Nelson Mandela and said that my foreign policy will ensure that international aid and development cooperation will be in line with efforts to ban child marriage. So using foreign policy, using soft power diplomacy and development cooperation as a tool to address child policy is another very important effort by intergovernmental organizations like the European Union, like the United States, which obviously has a lot of power in development cooperation. So the level of public development aid is made dependent on the recipient country's commitment to complying with the requirements in the fight against early and forced marriage. So this is once again a carrot and stick approach. So development cooperation will be dependent, will be contingent upon a country's reciprocity in addressing child marriage. And then it also calls for UNICEF, UNFPA, and the EU to create triangular programs. And implementation of these programs build on relevant conventions and texts, as well as specific goals adopted by the UN General Assembly. Escalating conflict, the EU recognizes, exacerbates child marriage and its twin, forced marriage, are important tools of violent extremism. I think that recognition is important, that violent extremism thrives on forced marriage and child marriage, and that the prevention of child marriage should be a part of the strategies to address extremism, should be part of countering violent extremism and preventing PVE, Preventing Violent Extremism. However, what is not in that resolution, which I am going to be speaking of in the European Parliament and in my recommendations to strengthen in this resolution, is that the resolution must also speak to the importance of women's campaigns, because as I discussed earlier, most of these law reform initiatives, even if they are not perfect, even in their incomplete form, even in its unfinished business form, have been lobbied by and propelled forward by women's campaigns. So give us books, not husbands' campaigns. Strong women's rights movements are important, and importance of campaigns that are culturally sensitive need to be incorporated into the EU's resolution. And then finally, what I would like to suggest is a case study from Indonesia, which helps to sum up my own thinking in this area. In May 2017, female Islamic clerics in Indonesia issued an unprecedented fatwa, a fatwa, using cultural religious provisions against child marriage. This is the first time where I have grappled with a fatwa that has positive implications, right, against child marriage, and urged the government to raise the age of marriage from 16 to 18. Although the fatwa is not legally binding, it is influential. It's a cultural tool. And what was historic and groundbreaking was that the fatwa was issued after a 3-day congress of high-level female clerics in the country. The Women's Ulema Congress, the highest Islamic authority drawn from Indonesia, Kenya, Pakistan, and Saudi Arabia. So once again, it's the transnational movement that propelled this forward. And the statement that was issued went even beyond child marriage. The Ulema Congress said, we want the world to know that we women clerics exist. So that existence is the bedrock principle, that women exist. And women's powerful voices exist and must be heard. And I want to end on the note that Hillary's recent book is imbued with, that with all of the failures that she's faced, her advice to women is that despite all setbacks, you know that just being in the room, you're a vital participant, and that makes me stand a little tall.